I would like to call on Nana Santibediato to do the opening remarks for us.
Good evening, ladies and gentlemen. We at the Danquah Institute are very happy so many people are here to participate in this important program. This program is important for a variety of reasons, but I would venture to say that the most important is to help all of us gain a better understanding of what the Supreme Court judgment in the case of Akufo-Addo and others versus Mahama and others really means. It is important to take stock of what has happened and how we got here. For, as I have often said, judicial decisions inform future conduct. If that is true, then it is hoped that the work of our distinguished speakers and panelists, what they've done before today, and which has culminated in this evening's program with public participation, will better allow us as a people to order our priorities and steps going forward in a manner that both vindicates our chosen form of government and our electoral system. It is important to look at this event in the context in which we're doing. In 1992, when Bill Clinton, a Democrat, was elected President of the United States, the first Democrat since Jimmy Carter in 1976, the Black Law Students Association of New York University School of Law decided to organize a symposium that would bring together distinguished scholars, academics, and practitioners, as well as top government officials, to take a look at the state of civil rights, voting rights, and education since it had been about 40 years since the Supreme Court's landmark decision in Brown versus Board of Education of Topeka, Kansas, which had led to the desegregation of education in America and to the Civil Rights Act of the 1960s. I had the privilege of leading the effort as coordinator, having secured funding from the Dean of the Law School. The findings, recommendations of that symposium found their way into many policy proposals for further reform in the areas of civil rights, voting rights, and education in many states across America. The Clinton government embraced the ideas that came from this effort. Such programs can therefore be very critical to how a country moves forward and how it develops its policy proposals. It cannot be gainsaid that the live telecast of Akufo-Addo and Mahama allowed Ghanaians to see for themselves what was happening at the Supreme Court. It also cannot be denied that the proceedings and the judgment have meant different things to different people. As fodder for political propaganda, the judgment's ratings have also been at an all-time high. It is important and necessary, therefore, that the actual meaning, as a matter of law and even in terms of political construct, of the various opinions of the judges be distilled and analyzed by experts for the benefit of us all. It is true that this exercise will go on in the law and political science faculties of our universities, but given the popular representation of the case through live media, it is important still that public intellectualism play a role in understanding what the judgment means. Not everyone who wants to know will have the opportunity to read law journals and reviews which would normally contain such critique and analysis. As I have said, judgments and judicial edicts inform and determine future conduct. And though, as a rule, a judgment may affect only the parties of a case directly, yet indirectly, as a result of the concept of precedent, among other legal principles, they affect all of us. So what future conduct does this judgment determine or require? There are a lot of questions which arise from the proceedings, the answers to which will help us arrive at a roadmap for future conduct, and this is what our panelists will help us do. Why did the Supreme Court refuse the petitioner's request for pink sheets and collation sheets? Why did the Supreme Court, in a matter of such constitutional and public interest importance, not require the EC to produce all documents used in the conduct of the elections? Why did the Supreme Court essentially treat this case as a private rather than a public litigation? Is there any textual or philosophical basis in the Constitution to buttress Justice Atuguba's claim that in Ghana, as elsewhere, the judiciary strives to sustain electoral outcomes rather than overturn them? Is the position of Justice Ansah that once a mandatory constitutional duty has been placed on a presiding officer to authenticate and sign pink sheets, failure to do so should lead to annulment of, quote, innocent votes sustainable in the face of Article 42. Is overvoting really just ballot stuffing? And if so, does it matter? Is law truly irrelevant in terms of the 2012 elections? Is a person now estopped from challenging election results once their agent has signed a pink sheet? Ladies and gentlemen, we are here to find out answers to these and many other questions, and the Danquah Institute is of no doubt that our speakers will help us do just that, and in the process, with your participation, reveal the heart of the judgment in Akufo-Addo and others versus Mahama and others to us all. Thank you very much, you're welcome, and may God bless you.
Thank you very much, Nana Santi-Bediatu, a senior fellow of the Danquah Institute. He's one of the finest minds that we pride ourselves on being acquainted with. Nana, thank you very much. Shall we please give him another round of applause? It is now my singular honor to invite the members of this evening's panel to the high table. And I would like to start with I'll give a very brief introduction. The moderator would delve more extensively into their profiles. I'd like to start with Mr. John Atefa, who is a senior statistician. Mr. Atefa. Mr. Sam Okujeto, a senior, renowned lawyer. I have been made to understand that if he had been in England, he would have been more than a QC, which is why I can see another fine lawyer behind him carrying the stuff. Dr. Maurice Ampao, a renowned legal practitioner. Professor Kwame Frimpong, founding dean of the Gimpa Law Faculty. Professor Frimpong, in his usual manner, has refused to let anybody carry anything for him. Mr. Kisi Ejabing, a senior lecturer at the Law Faculty, University of London. I am casting my eyes about, but I cannot find him. However, Mr. Sario Chudako, Executive Director of the Danquah Institute. These are the members of our panel. moderator is in the person of Dr. Maurice Ampao. He was born in Sekondi in 1968 and was called to the bar in 2001. He additionally gained his doctorate in the year 2011. And for all the work that he has done within the legal field, he was given an award by the West African Nobles Forum in 2011. He has also gone ahead to establish the Legal Advocacy Foundation, which he did in the year 2010. Dr. Maurice Ampao, it is now your turn to take over from me.
Good evening. I'm so excited to be here and very humbled as well. I know everybody remember me on the face of the pink sheets at 83, as I was busy doing the court analysis. I want to humbly invite the first speaker, Professor Atifa. Professor John Atifa. John Atifa to be here to first make his speech and give us his analysis.
Thank you, Mr. Moderator, for conferring on me a professorship. When I was being introduced, I thought they were going to say I was a lawyer, because I think in the last 8 months, I undertook a crash law course at number 1 Unyan Street, Nima, in the company of these very bright and experienced lawyers who held this country to a spell for about close to 8-9 months, and all of us had to just sit and listen to them so that we could understand what it is, how they translated the statistics to legalese for all of us to understand was quite interesting. But today my job is very simple, just to tell you what it is we give the courts, based upon which the court arrived at its decision. This is the statistics that informed the case and that led to the decision, sometimes saying that we didn't have enough to justify something, or what we had did not say what they wanted and all that. So I just take it through just 10 minutes of your time, about 10 slides. The first one is going to overvoting, and here I'm talking overvoting, not ballot stuffing. What we sent to the court, we said that overvoting covered 1,722 polling stations. And in these 1,722 polling stations, the total votes that were affected came to 745,569. In the last election, with the net loss of 155,000 votes, would have called for a rerun or a runoff. So overvoting alone led us to a situation where John Mahama's votes would have come down from 5574768 as declared by Farijan to 5070747, and he would have obtained 49.47. And Nanado would have had 5022,700, which would have given him 49%. Therefore, nobody would have crossed the line to be declared president. So that was overvoting. And look at it, we had 1,722 polling stations involved in this. But we had somebody say to us that there were not enough votes to make a decision. The next slide, one of the issues that came up was also whether in filling the forms, if somebody left C1, I suppose now everybody knows C1. Okay. C1 was left zero or was made blank, was not filled in, did it matter? That was the argument by the other side. So we said, okay, we take out those places where the people did not fill in C1 and just do the analysis again. And then when we did that, we still got a situation where we would have had to have a runoff because nobody got more than 50%. So, and there we had 1,499 polling stations. I think those numbers are quite substantial. When we come to the next one, where we are null votes due to voting without biometric verification, there 2,020 polling stations were affected by that infraction. And when we dealt with that as well, you were going to net off 813,866 votes, leaving John Mahama with 49.26 and Addo. This was almost a dead heat if you dealt with just biometric verification alone. So if you decided that the only infraction that mattered in the election was biometric verification, no voting without biometric verification, we would have still had to go for a runoff. But that was it. In the case of no signatures, we had 1,638 polling stations impacted by this. And that also led to a situation where nobody crossed the 50% mark. And therefore, if the courts had so held, would have had to go for a runoff. But that was not to be. So I'm dealing with just the three because the other three, the whole court decided that those were no issues, that duplicate serial numbers did not matter, duplicate polling station codes did not matter, and polling stations that had sprung up on the day of elections also were to be considered as normal. As such, when we put all the three together, and this is what we presented to the court, if all three infractions had been accepted by the court, then the total of 1,802,221 votes would have had to be annulled. And these three infractions covered 4,487 polling stations, 4,487 polling stations. We're dealing with 27,002 polling stations. So this is quite a huge number. And with that, if you put all three together, then Danquah would have had to be declared the winner with 51.28%, and all the others would not have mattered. But as fate will have it, the court said to us that we didn't have the figures to support any of those infractions that they found, even they found for us. So here we are, and it is part of the dilemma or the confusion that some of us are having to grapple with. And it looks like not only when it comes to voting or to elections, not only would the court say to us that the law does not matter, even the statistics do not matter. So on that note, I leave you to the lawyers to continue since my law degree now expires.
We have all learned something based on the statistics, and at the end of the day, the Supreme Court judges have actually come out with their verdict, and they did not agree with the statistics. And then at the end of the day, they said dismissed. So now second is our renowned lawyer. He taught me legal advocacy. He's a lawyer of great distinct. He speaks his mind. So a lot of people do not understand him. He says it as it is. And I'm sure with his number of years at the bar, he more than qualified to become a Supreme Court judge. So he's also good to. So he's also an authority. We invite our own papa, brother, uncle, and everything, Sam Kujato, to come and give us a silence.
Good evening. A mention was made of the former chairman of the Council of State, whose body arrived this morning. And it's important for me to put on record that he and I were classmates in the secondary school from Form 2 to Form 5. And that exactly 2 weeks before his death, exactly 2 weeks, the 2 Saturdays previous, we were together at the funeral at Angloga. In fact, the funeral of my brother-in-law, and I was with my elder brother, Dimagaga, Pujeto. We all sat together and conversed, and he left. Oh. And when I heard about the Westgate, in fact, I heard about Westgate, and then it flashed through my mind. I said, I used to shop there if I go to Nairobi, but I was not in Nairobi, I was here. Then I said I had families and relatives in Nairobi. I pray none of them was there. So Sunday morning I called my brother and I said, my nephews are there, my cousins are there. He said they are all safe, but your classmate Kofi-Addo is no more. Sometimes it makes you feel how light we are. Oftentimes I remind people that we are nothing more than a puff of breath. And even that is loaned to us, and the owner can call for it at any time without notice. So when we assemble in forums like this, let that be a reflection on us. Sometimes we see so many people are so puffed up. And we said, no, please, you are nothing. You are absolutely nothing. But it's also important for us to appreciate that God knows best, and that whatever happens, He knows it. Not that He causes it, but He knows it, and He even allows it. And so it's on that vein that I would like us to take a cursory note. Since there are other speakers, it's important, since we have not compared notes, it's important that one should not say too much to deprive the others of an opportunity to speak. I had not been in the court. There was so much to do. I followed the proceedings on television and radio when I'm available. And on the day of judgment, I sat in the office and I was watching the television and I saw the anxiety in the face of all the people where the cameras were moving up and down. And then when the judges came and they made the pronouncement by the president of the court, and then people called me and they said, so what was the judgment? I said, I have no idea. And then the radio station started phoning in. I told them I will not speak on the matter until such time that I had an opportunity to read the written judgment. Otherwise, I wouldn't make a fool of myself. Now I've had the opportunity, I have read the full judgment, 533 pages of it. I think it's the longest in the history of the judiciary in Ghana. And mind you, I have spent exactly 50 years at the bar, so I should know better. So what was the judgment? I think that is the important question to ask. Now, the first day, I thought I heard something about 6-3. That 6 decided against the petitioners. I think that the following day I heard it was 5-4. Now, when I studied the judgments to the end, I came to a different opinion altogether. And I'm going to explain that to you in a few minutes. You see, when you see the judgment, you will see that Atuguba, Adrinyina, Baregbe, and Akoto Banfo decided to sustain Mahama as elected. And you also see that Ansa, Ousu, and Anim Yebua said that he was not elected. But you know that there were 9, is that not correct? So if you take the 4 and the 3, what do you get? So what happened to the other 2? And I think this is where the issue becomes dicey. Now the other 2 are Doche and Bafuboni. And I will read something to you which will intrigue you. I have taken the trouble to, at least, I had it on my machine, so no, don't worry. To make a print out of only the pages that I thought were relevant for the purpose of establishing what I want to say. Now, when you come to Doche, and you see page 405 of the judgment, you see that his decisions were duplicate serial numbers, voting without biometric verification, unknown polling station categories, duplicate polling station results. Is that I reject those claims outright, and no consequences arise. They are therefore dismissed. However, since I have upheld in its entirety the no presiding officer signature category, albeit with a different and much reduced set of pin sheets, I must admit that this may affect the outcome of the results of the presidential elections. Then you refer to table 12A of volume 2B of the petitioner's address. The petitioner relief 1 will therefore be granted in respect of no presiding officer signature category in terms of my decision as is contained in the main body. Then in the following page, 408, he continues. Similarly, the petitioner will be deemed to be successful in respect of their relief 1 in the overvoting category in terms as shall be determined using the roadmap as indicated in the main body of the judgment during the audit of the affected pin sheets. Then he goes on. Relief 2 is, however, categorically dismissed. in respect of Relief 3, in view of my decision in the overvoting and no presiding officer signature category, and subject also to the total tally of votes in these two categories, the audit shall disclose where the total tally of votes in the same category reduce the total votes attributed to the first respondent to fall below the 50 plus 1%, then in that case, in line with constitutional provisions in Article 63(3), I will direct that there should be a rerun of the presidential elections in only the affected polling stations between the first petitioner and the first respondent. This is the conclusion of Justice Doche. So I think you are getting the picture clear now. All right. Now, who is left? Bafubon. Now, Bafubon, we can come to page 496 of the judgment. And these were his conclusions. I dismiss the petitioner's claim to annul votes on account of claim of duplicate serial numbers as frivolous. 2, I dismiss petitioner's claim that votes should be declared invalid on account of non-signing by the presiding officer. Well, he gives a reason. To disenfranchise hundreds of thousands of voters through no fault of theirs, because the presiding one fails to sign will not have a place in modern democratic governance. Then 3, I uphold the principle that once overvoting is detected in a polling station, the elections there are accompanied and should be cancelled, are compromised, and therefore should be cancelled by the voters there, should be given a second chance to cast their vote. However, if that in view of the admission made by a second petitioners with regard to some pink sheets and the many clerical errors, I find that the number of pink sheets affected in this category has so reduced that the votes affected are not too significant to make any impact, even if they are cancelled. I dismiss the claim on this ground too. Now, the strange part of this is that he did not give any figure. So the question to ask is, how did he come by that conclusion without figures? I realize that some people are afraid of mathematics. And if you recollect, Dr. Baumia had wanted to use electronic media to illustrate these things, and they were rejected. And I was astounded and shocked. Why? Because this is the standard practice all over the globe now. We are in a technological age. You can't understand. There is no way you can understand figures if they are not illustrated. There is no way you can do that. And since I'm much older than they, and I use electronic for everything that I do, I don't believe that they are lazy. But more importantly, there is a fourth reason that Afobani gave. This is the most intriguing part, so please pay attention. I hold that the petitioner have discharged the burden of proof on them that voting took place in some polling stations without prior biometric verification. This was discriminatory since other persons had been turned away for their inability to be verified. All those stations affected by this phenomena should have their votes cancelled and the voters given a second chance to vote again. The question now is, how did they come by the assumption that the petitioners lost the case? The judgment does not establish that. Now, both Bafoboni and Doche were asking votes to be cast in the certain areas where this malpractice had occurred. Some were calling them infractions. They've given all manner of names to them. And we say an infraction is an infraction, no matter by what vituperative epithet you add to it. It does not change its character. An error is an error, no matter which way you put it. And so, the Constitution is very clear. It says that if a candidate does not obtain more than 50 plus, election must be what? Rerun. So you cannot say that election should be run in some constituencies. Because once the 50 plus is not attained, there must be what? A rerun of the whole election. And so I believe that at the time they were making those statements, they had not properly addressed their mind the constitutional provision. And so my reading of this judgment is the fact that it was 5-4.
In favor of petition.
Rather in favor of the petitioners. Now, perhaps of course it is too late, but I find that this is important. For the simple reason that today I read in the graphic that my son, yes, in fact, it should be my son, Dr. Wereku Broby, was making fun of this symposium. It's like, you lost the election, what is your business? Well, the truth is that, yeah, we lost the election, that's true. That is what the court said, isn't it?
Yes.
Yeah, but I am also reading what the court said. I didn't write the judgment. And then, of course, the strangest part of all this is that the court, those who gave judgment for the respondents spend so much time dwelling on the word shall. Now, the word shall was defined in the Interpretation Act to mean that it is mandatory. But I also took the liberty to look at Black's Law Dictionary, which is the dictionary that we all lawyers use. And it gave the meaning of the word shall, and I will read this to you carefully. It says shall, as used in statutes, contracts, or the like. This word is generally imperative or mandatory. In common or ordinary parlance, and in its ordinary significance, the term shall is a word of command, and one in which has always or which must be given a compulsory meaning, as denoting obligation. The word in ordinary usage means must, and is inconsistent with a concept of discretion. It has the variable significance of excluding the idea of discretion, and has the significance of operating to impute a duty which may be enforced, particularly if public policy is in favor of this meaning, or when addressed to public officials, or where public interest is involved, or where the public or persons have rights which ought to be exercised or enforced, unless it is contrary to intent appears. Now, I noticed something interesting because I saw that Mrs. Akufo-Addo actually agreed with this in her own judgment. She said it was mandatory. But then she went on an excursion. And unfortunately, that excursion was on page 525 of the judgment. Article 49 is couched in mandatory terms. Undoubtedly, it is an infringed provision. This is Akufo-Addo, which can properly be amended in accordance with Article 290 of the Constitution. Under the 45 Constitution, the Electoral Commission is vested with the power to conduct and supervise all public elections and referenda. Then she goes on. Since the provision is couched in mandatory terms, clearly, where the signature of the presiding officer fails to appear, it does not admit of any argument on a literal interpretation of the said article that there has been a breach and therefore the result ought to be nullified. This is what she said. And then, when you turn the following page, she goes on a different discussion. However, it has been heard in a long line of decisions that a strict, narrow, technical, and legalistic approach to interpretation of the Constitution, as embodied in our hopes and aspirations, must be avoided. And he quoted Professor Latiba was the intellectual in the court, so they all got married to him in thoughts. And Latiba said, these days, a literal approach to statutory and constitutional interpretation is not recommended. Well, the truth is that I think they went off the mark. And I will tell you why I said so. I have not been able to get a computer to make a count, but I can tell you that in this Constitution, the word shall must have appeared more than 1 million times. And in each instant, you will see why it is so stated. Because of our past history. And I'm old enough to know the past history, since I've watched this country from independence to now. And I can tell you that since 1968, I have been directly involved in the political process. And so I know what had happened and why it was important that these mandatory words are put in our Constitution. At every level, the word shall is used and repeated. The powers of the president, you will see that in his appointment, they say he shall do so and so and so. You will see that in the case of the Electoral Commissioner, they say he shall do so and so and so. You see that in the case of minister, they shall do this and that. In fact, they are even categorically told not to be engaged in any gainful employment or business, which again is one of the issues that one of these days I'm going to take to the court for determination. Because both the members of parliament and the ministers are flouting the Constitution. And so, the shall in this Constitution means that it is what? Mandatory, it is unobligatory. It is not open for anybody to go and start talking about purposeful view of interpretation of a Constitution. Because that only arises where there is an ambiguity. When the words of a Constitution are clear. And don't forget, the Constitution is what? Is the supreme law of the land. Every other law is subject to this Constitution. I started in the Constitutional Assembly in 1968 when we made the first of our Republican constitutions. And I have followed up to today. And I say that Black's definition of shall is the shall which is in the Constitution. And therefore, it is an error for anyone to interpret it otherwise. But I think the exciting part, of course, in this matter is to say that since the courts by themselves, by what I have deduced from the judgment that has been read by each one of them, and of course they were not read. And this was the error. We knew, of course, that 533 pages would have taken a lot of hours to be read. And so what was supposed to be given on the 29th was a summary. And no summary was given. But how the president came by the statistics of giving this 5-3, which came to 5-4, which I have seen now should be 5-4 the other way around. I did not know how that came about. So God knows what he does, but I'm saying that this is what the law says. This is what the judgment has said. And those who thought that what we are doing here today is an exercise in futility, let me remind them that it's not everybody who can discern what I have discerned. And I'm sure many lawyers would have read the judgment without even noticing this. And therefore, all of us should be open to education all the time. Because somebody might see what you have not seen. Somebody may misunderstand the issue, and you might be able to help to clarify it. And I think this is why forums of this nature are important. So I congratulate the Danquah Institute for making this available. And I pray that they will continue to help us to expand, to expose, to discern, to discuss, so that we as a people can live together in peace and unity. Thank you.
Let's be on our feet. Keep on clapping. Show appreciation. Show love. My God. Next we have the great man. Say the great man. Prof. Frimpong. Oh, put your hands together. A professor of law, qualified barrister in Ghana, a lecturer, and many more. Please, let's acknowledge Oman FM, you're on live. Oman FM 107.1, and then Choice FM. So they are taking this live. The whole nation is listening.
Good evening, ladies and gentlemen. Are you sure you are here? Good. Teachers are used to noise, so great. You see, when you are following the steps of tsunami disaster, you know how difficult it is. So after Uncle Sam, I always call him Uncle Sam, what we could say is that the battle is over because he has declared, and we do hereby declare. I'm going to base my contribution on a story, which is always my trademark. About 2,000 years ago, a certain gentleman walked this earth. And for the Christians, they call him Jesus. His ministry occurred around 2 lakes in those days, but the lakes are still here. One of them is called Lake Galilee. The other is called the Dead Sea. Interesting. Why the Dead Sea? what happens is that when water flows into that lake, it stays, it doesn't move, and it stinks. So fish and other living objects don't survive. That's why they call it what? Dead Sea. In the case of the Galilee, when the water gets in, it flows out. So there's life. And Jesus' ministry was on that lake. And I hope Ghanaians will look at their lives within that context. Are you a dead sea or you are a Galilee? This judgment, we looked into that within that context. Is it giving life to Ghana in terms of advancing our democracy? Or is it bringing us to a dead end of our democratic aspiration? What is so interesting about this case is that nearly all the judges, and I would say maybe all the Supreme Court judges, are either the product of some Jando, not this Samuel, Professor Jando, on constitutionalism, or they must have read his source book with Griffiths, and how Ray Akuto has always been hunting this nation. And we would have expected judges who have gone through that law faculty will stand the test of time and reverse the danger. But unfortunately, they disappointed this nation, and once again, continues to hunt this nation. When will the Supreme Court wake up? I think it's about time. In this case, the critical issue is whether we endorse illegality or we take a firm position against any system of impunity that has been ravaging this nation over the years. And if you recall, just as the case started, I put up a short piece in the graphic with the title, Exorcising the Culture of Impunity in Ghana. And I had hoped that this case will set the precedent for us to move forward against all cases where people believe that when they have authority, they can do whatever they like. Unfortunately, this has set us so many years back, maybe even into the Stone Age, encouraging impunity. You all read before the case the way the electoral commissioner used to talk. Go to court. Why is he emboldened to make such pronouncements if he doesn't have the belief that at the end of the day, the end will justify the means? My concern about this judgment is the fact that now, if you read the judgments, particularly of Atukuba and Adinyira, putting too much faith in the polling agents, shifting the burden of responsibility onto them, that they should have exercised scrutiny over the voting and all that. Is that their role? No. As Uncle said, the presiding officer shall, he is the one with the mandate to ensure credible elections. And the question before us is whether we have had credible election. There are so many flaws, and I was struck by Uncle Sam, because I said to myself, oh, so I was not wrong when the head coach himself is also saying the same thing. Because when I read the judgment, I was confused. To be honest, I was confused. And about a week ago, a year one law student came to my office and said, I've read one of the judgments. I don't want to mention the name. I said, it doesn't appear nice to me. When year one law student talking about one of the judgments. So at the end of the day, the real difficulty that we are all facing is whether this judgment has enhanced our understanding of democracy. Whether it has established a credible situation upon which we can build on our desire to have free and fair elections. If you read through carefully, what we are discovering is that it doesn't matter. At the end of the day, all that we need is that the results are declared. And if you are not comfortable, go to court. And if you go to court, nothing. Because your polling agent didn't do his work. Are we advocating the very thing we are trying to prevent? That at the end of the day, let us decide at the polling station whether you win or not. And it's a very dangerous thing for Ghana, and we condemn it with all our strength. Let's look at some instances where I believe some of the presentations didn't match the whole desire to come out with a credible piece of judgment. If you read the presiding or the president's judgment, for instance, you notice that it has a critical weakness, with due respect to. There are so many contradictions.
Yes.
It's incoherent.
Yes. Illogical.
There are so many serious quotations, beautiful, but they are not advancing constitutionalism. When you are dealing with interpretation of a constitution, as Uncle Sam mentioned, the supreme law of the land is ideal to also look for authorities of similar constitutions to buttress your case, not relying on criminal law, company law cases. They are not of relevance. And unfortunately, any attempt to use syllogism, which I suppose is not clear to some of you, you have the major premise and they use the minor premise to draw a conclusion. That is ideal for year one. It's not for constitutional dispensation. So you can't quote extensively and then simply say, that means so and so. You have to analyze and discuss in detail, which is very important in constitutional development. If you look at the judgment by Justice Dingira, you notice that almost half of her judgment was devoted to the role of the polling agents, which I don't think is very important, because as Uncle has just explained to us, the mandatory requirement is not on them. I recall, for instance, at one page where she quoted and said, if any, I said that, no, that doesn't apply to the polling agents, but only when presidential. Obviously not, because as far as the May presidential election is concerned, you also have what? polling agents. And she said no, she said rather in referenda that if any apply. That is not correct, because polling agents are not necessarily mandated to be present. It's up to the candidate, because they may appoint. So the candidate has no obligation to have a polling agent present. And if that being the case, then their signature is of no significance. And therefore, for a judge to rely on their signatures, I think it's just a major flaw in the judgment. And you can see that most of the judges say that. I think one finest statement came from Justice Anin Yeboah, where he said they should be careful about over-reliance on foreign judgments. Because you know, in this country in particular, if I may give myself 1 second in case I can get quickly to a quotation by, excuse me, the West African Court of Appeal in the case of Wallace Johnson. When we were warned as far back as about 1950s that in this country we are not bound to rely too much on foreign judgments, but rather on the penal code, in those days the criminal code, where the Privy Council specifically said that that judgment shouldn't be, the over-reliance on that case should not be of any significance. Well, it appears that it didn't come. But the point that the court made, oh, here it is. He says, the fact remains, however, that it is the criminal code of the Gold Coast and not in the English-Scottish cases that the law of sedition for the colony is to be found. The code was no doubt designed to suit the circumstances of the people of the colony. The elaborate structure of Section 330, and you can say the elaborate structure of our Constitution, suggests that it was intended to contain, as far as possible, the full and complete statement of the law of what? Elections in Ghana. It must therefore be construed in its application to the facts of the case, free from any glosses or interpolations derived from any exposition, however authoritative, of the law of England or Scotland. So when you quote extensively from any jurisdiction and without necessarily doing serious analysis and therefore draw the conclusion that it is automatically the case in Ghana, is wrong, and we should not endorse that. Now going to the specific issues, 3 of them that the courts agreed. Overvoting, or maybe ballot stuffing. Or is there a third definition? Ballot stuffing. Okay, there is a third one. Good. This is a simple mathematical issue. Arithmetic, I see. When we did Lacombe's, you were not there by then. Good. Has there been overvoting or not? And KPGM or whatever they call it provided the evidence. So I'm wondering why the court took 8 months to address these simple issues. Couldn't the case have been dealt with within even 1 month if they chose to? I think it was unnecessary for the long duration, particularly for the joinder. It was not necessary. And I think even, I've forgotten which judge, was it Akufo-Addo or something? I think Dote, mentioned that, they felt it shouldn't have been necessary. Anyway, statisticians exist, professional accountants they could have been mandated within a relatively short period to address these issues, and the case could have been resolved. What seems to have been a major flaw throughout is the fact that they are saying, even though irregularities took place, if we allow the irregularities and all those malpractices and others to be used to annul, that means we are disenfranchising Ghanaians against Section Article 42. Let me make it very clear. You disenfranchise someone when you make sure that he or she doesn't have a right to vote. When you annul or cancel, whichever you prefer, an election, it does not necessarily amount to disenfranchisement. You are merely declaring that appropriate legal procedures have not been complied with. And if that's the case, we have to go back and correct that. So that doesn't amount to disenfranchisement.
Yes.
Otherwise, any provision which requires you to comply with a particular practice in order to vote amounts to disenfranchisement. If we want true nature of the right to vote, then we don't have to have any law. You wake up and you just vote. But we need regulations based on the same constitution before you can vote. And therefore, you need to comply with those. It's part of the laws of the land. Yes. And so I don't think the court is right when they are saying that by necessarily declaring null and void any infringement of the constitutional provision amounts to infringement of Article 42. No, it's not the case. Yes. What about presiding officers failing to sign? The interesting thing is that they are trying to tell us that if you don't sign, it doesn't mean anything. Then why do we require signature on the basis of the shall requirement? Shall mandatory, may empowering, but permissive. Difference. Once you are mandated to sign, then it's the requirement for establishment of the credible voting. And if that hasn't taken place, then there is no election which is valid and it should be cancelled. Yes. And finally, the third issue, that is the biometric. Thank you very much. Yeah, the third issue is the biometric verification. Why do we require biometric verification? Then inter-party caucuses and all that agree that this is a requirement. Why? Just to be sure that we have what? Credible election. At the same time, we are being told that even if there was no biometric, it doesn't matter. So at the end of the day, let us ask ourselves this critical question. Why do we need to lay down certain procedures for purposes of holding election in the country if those procedures don't mean anything? I would advise very strongly that for purposes of all future elections to be credible, to be transparent, and to be legitimate, we need to go back to the drawing table and ensure that all those rules and regulations are complied with. But my main worry is that, assuming for purposes of discussion, if any of those flaws emerge, where do we go after this case? And I hope and I wonder whether the judges took this into consideration in their judgment, because it's sending a very wrong message to the nation that it doesn't matter. Once it is declared and shall be so. Ladies and gentlemen, I pray that the younger generation should look at this case again and think about how best we can move forward. Otherwise, it's not laying down a proper foundation for us. In terms of the future, I would suggest that maybe it's about time that we actually establish a constitutional court modeled along the South African country, for instance, where constitutionalism means a lot, because to rely on Supreme Court judges who seem not to have sufficient knowledge of constitutional Constitutional law is not something we toy with. Let's be very serious, because it's the foundation of our very existence. There's an able quotation from Justice Emerson in a case in Botswana when he laid down clearly what is expected of the rule of the Constitution. And he concludes with a statement that nobody, no one can claim to be above the Constitution. If you watch this particular judgment, indirectly, some of the judges are saying they can declare constitutional provisions invalid. So they are above the Constitution. It's not allowed. So, because the moment you allow statutory provision to take precedence over constitutional provision, you are declaring that the Constitution is no longer the supreme law. So these things they never address. So that's why I'm suggesting that let us please seriously consider establishing a constitutional court which will now delve into the real constitutional issues instead of just quoting left and right without appropriate well, I wouldn't like to concur, as we usually say, but indirectly, and seem to be saying the same thing, that somehow they inadvertently ruled in favor of the petitioners, but they didn't admit it.
About Maurice Ampao, because it seems as if the nation did not know Maurice Ampao. A lot of them being, then all of a sudden I appeared on TV3, and then they kept me there because of what the social media, the text messages and then the information that is coming actually showed that I was actually being very, very independent and very objective. But my background, I am a monochrome and a chim. My father was the late G.D. Ampao, Gibson Dote Ampao. No, not the IGP, the lawyer, the minister of health during Buzia regime. That is my father, I'm the last born. And I think he worked with some Udato. But he calls me the bad boy. because I decided to go to Chambers one day to do some 419 that I got on him, and then he disowned me. But because my father did not know my future, out of his 12 children, he married three wives. Every wife, my father gave 4 children. My father was a very disciplinarian. 4. And out of the 12 children, the bad boy took over him and became the lawyer. He died in 1995, and at that time, Akufo was about to stand for as the president in 1996. So NPP people came to me, and then that was it. But I went to the TV3 with this mindset to go and speak to the ordinary Ghanaian. I decided to be very objective, took the petitioners on when I have to take them on, dealt with the respondent as well. And I decided also to look and watch at the conduct of the bench. And today I want to speak my mind. So Ghana, listen to me. I'm speaking my mind. To begin with, I think that the Supreme Court judges are highly favored. That among thousands of lawyers who are capable of becoming Supreme Court judges, they were given the opportunity to become Supreme Court judges. It's the favor of God that found them. We have thousands of lawyers who have practiced for more than 50 years, are men of substance and integrity, and they can also occupy that position. So they are not any exceptional people. They are ordinary as we are, subjected to the Constitution and the will of the people. Now, as I sat there on the 29th August, and the judgment was, the verdict was delivered. If you look at my body language, those who watch me, I became very confused. Because I did not know what to tell the people. Because if the Naba were to ask me, what is the meaning of the judgment? It would be a disaster. So I will say that the delivery, and I like the word, I want people to know, the delivery of the judgment did not meet the expectation and aspiration of the ordinary Ghanaian. How the judgment was delivered did not meet the expectation and aspiration of the ordinary Ghanaian. We were kept waiting, anxiously waiting till 1 o'clock plus. Our justices came with no explanation, no apology to the people of Ghana, and then quickly said, this is our judgment. Dismiss, 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 dismiss. Our judges should know, our Supreme Court judges should know that they are not above the law. They are subject to the Constitution and the will of the people. Because according to the preamble of the Constitution, the will of the people matters. And then according to Article 125(1) of the Constitution, justice emanates from the people. We all have the capability of judging. We were born judges by yourself. God imbibed in us the ability to judge. So we are capable of judging. But we have entrusted the ability to judge to the judiciary. So they judge on our behalf. Therefore, we are expecting the judiciary, as they render the judgment, they should not have only looked at the petitioners and the respondent. They have a duty towards the ordinary Ghanaian and the people. Not only that, the judgment was very confusing, the judgment was also highly technical. And very confusing to the ordinary Ghanaian, which produces mistake and error. Now, seriously, none of the 9 justices of the Supreme Court, and everybody should go and read the judgment, none of them actually commended the people of Ghana. None of them. The role of the people of Ghana in supporting them in prayers, the discipline that the people of Ghana showed, the commitment, the media contribution, the loss of revenue by those private and print media, civil society, and even the National Peace Council were not mentioned. They only commended KPMG and then the councils. This is unfair. Yes. Because the people of Ghana have also contributed in no small way in helping to maintain the peace for our judges to be able to deliver the judgment. So they should also acknowledge the people. Now, my worry is that given the position that the Supreme Court judges have taken, the majority position, with also the law on section 64, 63, 9, 64, where the Electoral Commission, after declaring that somebody has been elected, there is this presumption, serious presumption in law that that election was properly done. Number 1. 2, the Constitution also allows the person who is being challenged to be sworn in, and he will start exercising presidential powers by appointing ministers and security people and teaching himself in power. Will make it very difficult for anybody who wants to attempt to petition, to challenge the validity of the elections, to succeed. Now, apart from the 2, we have a situation whereby, according to Justice Atuba, very interesting. If you read his judgment, Atuba, he said, and let me read. That's the last page. He said, for starters, I will state that the judiciary in Ghana, like its counterparts in other jurisdictions, does not readily invalidate a public election, but often strive, do everything within their power in the public interest to sustain it. And that is exactly what our judges did. As I sit watching, you can see that if that is the mentality of the majority judgment, that means that the whole petition was a nullity. Because as I sit and watch with this quotation, it means that the majority have made up their mind that at all costs. Yes. And this is a highly prejudicial position, yes, taken by the majority decision. No wonder you can see the heckling that was going on. Yes. No wonder, instead of inquiring into the truth, the same Supreme Court who was accusing the petitioners of using technicalities, adopted technicalities to prevent the truth. They did not allow the EC to produce the voter register. They did not allow the EC to produce collation forms. They did not allow the EC to even produce the original pink sheet. Sorry to Philip Addison. Sorry to my senior. The kind of heckle that he went through. All in striving at ensuring that elections are sustained. So, the question that I put, I don't think if this is the position of the Supreme Court judges, coupled with the law as it is, no petitioner in Ghana can win an election petition. I'm therefore calling for an independent electoral dispute body from the judiciary, who will be so independent, and then future elections where there are disputes, we refer those matters to them for them to look through, because the court have made up their mind that they are going to do everything possible to ensure that no petitioner succeed in election disputes. So it's not surprising that the petitioners lost, because no matter how you try, evidence was suppressed, the law was taken in such a way that at the end of the day, we were being told that when it comes to constitutional interpretation, we bring in what we call spirit. And only God knows the spirit, because everybody has a spirit. And then we have what is justice. And sad enough, I read a whole paragraph where the presiding judge was justifying violations of the Constitution. Was saying that this is not the first time the Constitution has been violated. Yes, because if a violation does not lead to injustices and does not cause any injury or harm, it doesn't matter. That's the position. If you read the presiding judge, that the violations has occurred in certain, it's surprising that the majority were able to cite a lot of authorities to buttress the point that this is not the first time that we are violating the Constitution. Constitutional violations have happened. But the only thing is that when it happens and it does not cause any injury or harm, leave it. Sad enough, those who watch me, and one who actually advocated that look, the Constitution is supreme. I was calling on people to be very careful. People should hold the Supreme Court judges in high esteem, but they are doing my work well. But with this posture, you see what is happening now. Because of the way we've treated the Constitution, we have allowed violations, and we are using spirit and then intentions to justify violations. Now we have a professor who is doing political science. When he had problem with the Constitution as to whether the president travels, who should take place, with that little difficulty, that professor is calling that the Constitution should be thrown away. The Constitution has no value now. Yes. People are not respecting the Constitution. But the judges are forgotten that their powers are limited to the Constitution. And we have failed to promote constitutionalism and rule of law. It's sad. Now, very sad indeed is also the fact that we have a situation whereby we are talking about the petitioners only relying on B sheets. And then B sheets also does not have any legal status. And the same B sheet, they are accusing that it was signed by the polling agents. These inconsistencies, the B sheets have no legal status. And the same B sheets too, when a polling agent signed, it is valid. But at the same time, it is not of any material effect. Now, conclusion, I want to call on all who believe in constitutionalism and the rule of law in this country that the battle is not over yet. We should continue to speak our mind, continue to be faithful. And I also want to say something as I take my leave. I was sad when Sir John and others suffered serious passion from the Supreme Court judges, whilst others were doing more highly controversial statements, and nobody seems to care, and they were left on the hook. God save Badagana. Now let me introduce my next guest, a nice gentleman, of course, cute but full of knowledge. Let's welcome Kisi Ajabel.
Good evening, ladies and gentlemen. After my grandfather lecturer has spoken, I don't know what to say again. He is my grandfather lecturer because he taught Professor Mensa Bonsu and Professor Mensa Bonsu taught me. I'll just zoom straight into my presentation. It seems to me that a judicial challenge of the validity of the election of the president of this country automatically calls for a determination of whether the person whose election is being challenged obtained the constitutional threshold of more than 50% as is required by Article 63.3. Therefore, a judge who fails to appreciate this would fail in his judicial capacity, and the judgment so delivered cannot be said to be in fidelity to the Constitution 1992. No matter how frivolous a judge may conceptualize a petition, an election petition to be, the judge should always bear in mind that elections are about numbers, and not merely numbers, but the number of valid votes cast in favor of each candidate. That is why we have that constitutional threshold in Article 63.3, and it puts the matter beyond debate. This is so especially where both the petitioners and the respondents, as we had in this case, strived over the actual figures validly obtained by their preferred candidates as recorded in the thousands of results declaration forms, aka pink sheets. It seems to me, therefore, that the judge, no matter how exalted, cannot reasonably conclude that a person whose election is under challenge was validly elected or otherwise without engaging in a mathematical exercise of whether the person in question obtained valid votes which satisfies the constitutional threshold. I want to tell their lordships that it is not merely enough to say that by some rebuttable presumption in our evidentiary setup that official acts are presumed to have been validly done. Therefore, the figures as provided by the EC are presumed to be correct. Especially whereas in this case, the EC itself admitted, though tenuously, that irregularities were recorded in respect of the elections, and indeed, the results of some polling stations were not as a result. It is in satisfaction of this constitutional threshold in Article 63.3 that the two issues were posed to be resolved by the court. One, whether or not there are statutory violations in the nature of commissions, irregularities, and malpractices in the conduct of the presidential elections held on 7 and 8 December 2012. And two, whether or not the said statutory violations, if any, affected the results of the elections. I would have thought that the verdicts would have run along these lines and the judges would have voted on these two issues. It becomes therefore perplexing that instead of voting on the two issues as posed, the verdict delivered on 29th August last was rather a vote on the various categories or irregularities and statutory and constitutional infractions complained of by the petitioners. Indeed, I stand to be corrected, but I do not find any basis in law as to how a court can, in announcing the verdict, ignore the issues before it. But in fairness to them, all the judges, I'm inclined to say that all of them answered the first question in the affirmative, although they did not know they were doing that. That is, all the 9 judges concluded that there were statutory violations in the nature of omissions, irregularities, and malpractices in the conduct of the elections. I say so because I have to make sense of what they said. The first issue begets the second issue. If the answer to the first issue is negative, then there is no need for proceeding to the second issue. So having delivered the verdict as a vote on the effect of the various categories of infractions complained of, it becomes a logical conclusion, therefore, that all the 9 judges found violations or infractions. I say this, though, with some diffidence, because the reasoned opinions do not necessarily bear this out. If you go in to vote on the categories, you are telling us that you have found infractions. The net effect of this unhappy posture is that several of the judges concluded their opinions without addressing the very important question as to whether the person declared as elected actually crossed the constitutional threshold. Now I move to approaches to interpretation. I have heard it said that the judges who dismissed the petition adopted a purposive approach to interpretation, while those who upheld the petition engaged in a strict literal interpretation. After reading the reasoned opinions, it seems to me that indeed all the judges either claimed to be adopting a purposive approach or they appeared to be professing so. Then again, after reading the reasoned opinions, it seems to me that indeed it is very easy to tag what a person engages in with any label that sounds convenient. So a judge may say, "This is my preferred approach to interpretation," when in practice, the effect of what he is doing is the exact opposite of what he claims to do, or at least set out to do. In our judicial dispensation, I venture to say, especially in respect of cases which have the capacity to undo our democracy, we should always be minded that a cat has not become a dog just because one chooses to call it so. It still remains a cat. I'm sounding this admonition to all in judicial capacities. It should be received in good faith, because immediately one labels a cat as a dog, it becomes almost irresistible to proceed to treat the cat as a dog. Such treatment can only produce undesired results. It is said to be now settled that the Supreme Court's preferred approach, that is the Supreme Court of Ghana's preferred approach to interpretation, is the purposive or objective one. This has been stated and ad nauseum in a long line of cases which need not detain us here. It is therefore not surprising, as I said earlier, that all the judges either expressly call it in aid or at least were professing so. Simply put, this creature called the purposive or objective approach to interpretation is that under which statutory or constitutional provisions are interpreted in light of the purpose for which they were enacted. Perhaps no other issue, apart from the category of violations which most require the judges to exercise their interpretative skill, was that of the absence of the signatures of presiding officers on a number of the pink sheets. The question became the effect in law of the refusal or neglect of a presiding officer to sign the pink sheet. This question brought into sharp focus the role and importance of polling agents in the general scheme of affairs, and my seniors have touched on that, but I will go a little bit into it. the so-called majority opinion appeared to have decided that the signature of the presiding officer is immaterial, while the minority thought that the absence of the indicated signature was fatal. The question, it seems to me, becomes, what was the intention of the framers of the Constitution when they required in such a mandatory manner under Article 49(3) that the presiding officials shall sign the declaration form? What did they intend? Was it just for decorative purposes? Or was it meant to have biting effect?
Yes, biting effect.
First, it appears that all the judges acknowledge that the absence of the indicated signature is a clear constitutional breach. They all did.
Yes.
However, the so-called majority thought that this could be an administrative error. Mind you, they didn't say it was. They said it could be an administrative error, which error should not be visited on the voter. Fair enough. But mind you, no one knows for sure what informed the decisions of the several presiding officers to refuse or neglect to sign the declaration. No one knows. Then again, the so-called majority takes the view that this clear constitutional breach is cured by the signatures of the polling agents. That is to say, if a polling agent signs, then the absence of the presiding officer doesn't matter. In the words of His Lordship Atuguba, the President, and I quote him, in this case, it will be unfair and fraudulent for the petitioners to authenticate the results through the polling agent's signatures and then turn around to seek to invalidate on the purely technical ground of the absence of the presiding officer's signature. Unquote. Yet, inherent in this dictum of His Lordship Atuguba is a clear admission that the required signature is meant not for decorative purposes, but to authenticate the results at the polling station. If that is so, then no premium can be put on an unauthenticated declaration form. It cannot form the basis of the declaration of a person as a president. How is it that their lordships in the so-called majority welcome so gladly the signature of the polling agent as authenticating the declaration form, but so unhappily downplay the signature of the presiding officer as immaterial and relegate it to a mere technicality? I find this perplexing. How they came to this conclusion remains, in my opinion, in the imagination only.
Yes.
This is because the effect of the majority decision is that the signature of the polling agent, who, mind you, is not an electoral officer by any stretch of the legal imagination, is now said to legalize what is clearly a constitutional breach. So the net effect of what we have created is a creature now that I call a super polling agent, who will now call the shots at polling stations. If he sees that things are not going well for his candidate, he folds his arm, I won't sign. And because of the tenor of the decision, now the rule will become, when in doubt, just fill a complaint form. Because if you do not fill a complaint form, it will be held that because you did not complain at the polling station, you have waived your right to complain. So now, super polling agent, do what you please. Your signature validates the absence of the signature of the presiding officer. So whether the presiding officer signs or not, it is immaterial. As far as the polling agent signs, praise the Lord, hallelujah, we are home. Yet, there is a rather deafening silence of the majority, so-called majority, on the position in law, where the signatures of both the presiding officer and the polling agent are missing. No one said anything on that. If you're saying that the signature of the polling agent validates the absence of the signature of the presiding officer, yet you do not tell us if both signatures are missing, what the position in law will be, or can only conjecture. Then again, for some reason inexplicable, the position is now not so clear as to whether a person's agent can waive that person's constitutional right. If you are my agent for purposes of contract or land matters, perhaps depending on what I instruct you to do, you may waive my right, especially if I give you a power of attorney. But can you, by your action, waive my constitutional right? Can you, for instance, waive by your action, if you are my agent, my right to life, for instance? Can you do that? No one answers that question. It is just a blanket provision. Your polling agent signed. Don't complain. Another category of violations which required some interpretative exercise was voting without biometric verification. The effect of this occurrence was not decisively determined because the so-called majority took the view that there was no evidence of this. I venture to say that CI 75 put it in very mandatory terms that every voter shall undergo biometric verification, which ends with fingerprint verification, except for those who do not have fingers. Mr. Moderator, we cannot create laws and apply them as and when it suits us.
Sure.
If we do not want voters to be biometrically verified, we should scrap the law that so requires it. But if we want biometric verification, we should apply the law and apply it fairly. Fair observance of the constitutional and statutory safeguards serve to enhance public faith and confidence in fair elections and in the government itself, both of which are indices that are essential to an effective democracy. Why do I say this? We cannot permit others to vote without prior biometric verification, while we turn away others because they could not be verified. I use myself as an example, where I voted. I tried about 4 or 5 times before the machine finally said verified. The clear indication was that if I was not going to be verified by this machine, I was not going to be allowed to vote. Meanwhile, I heard on the radio that it had been said that some people somewhere should be allowed to vote without biometric verification. The Constitution guarantees the equal protection of all votes and equal weight should be accorded to each vote. One person's vote cannot be valued more than another person's vote. Why should I be told go home because your fingerprints cannot be verified while another person is being allowed to vote without biometric verification? I shift now to the question of overvoting. Here again, what we have is an inconclusive decision as to what amounts to overvoting in Ghana. We are none the wiser. In my opinion, a proper definition is not far-fetched unless we do not want to face up to it. All in all, it appears to me that underlying current of the so-called majority decision is born of the consideration that annulling the entire votes in specified polling stations affects the right to vote and unfairly disenfranchises the voters who were not at fault. But we should bear something in mind. A voter is hardly ever at fault. Hardly ever. Unless you go do something on your own volition, as in trying to smuggle things there, you will never be at fault. All you have to do is to show up, vote, leave, and go. How else can elections be annulled if we are looking for voters to be at fault? I would want to say that the court's first fidelity is to the integrity of the electoral process and not to individual voters. The same laws that enable entitled voters to cast their ballots also serve the purpose of annulling votes when those votes are tainted by irregularities and violations. Constitutional and statutory infractions at a polling station, in my opinion, render the votes cast there as illegal votes, notwithstanding the possibility that the individual voter may not have been at fault. Such votes as tainted cannot be reckoned as legal votes because to do so will be turning our one-man, one-vote system of representative government on its head. Instances of overvoting and voting without biometric verification egregiously taints the entire vote cast at a polling station. It's simple. See, in the case of overvoting, it is impossible to determine which voters cast more than one ballot. And in the case of voting without biometric verification, it is impossible to isolate the votes cast by the unverified voters from those cast by verified voters. In all these cases, the impossibility of the isolation of the votes cast in violation of the Constitution and statute renders the entire ballot cast at a polling station invalid, and no candidate can take the benefit of the votes cast at such a polling station. Mr. Moderator, it seems to me that the right to vote cannot be situated in a standardless system. The right of suffrage is limited by predetermined standards set by our Constitution and by statute, and the right should be exercised within those limits. Once the franchise is granted to the electorate, it cannot be exercised in a manner that is inconsistent with the predetermined standards prescribed by the Constitution and by statute. So adherence to these injunctions qualify a vote cast as a legal vote. Therefore, ballots in a box tainted with infractions of these injunctions cannot be clothed with a garb of legal votes, no matter the legal gymnastics adopted. Mr. Moderator, in saying this, I would also want to draw our attention to something. It appears we were confusing qualification to vote with entitlement to vote as far as the judgment goes. Whether a person is qualified to vote is a distinct question from whether he is entitled to vote. Indeed, qualification to vote is a subset of entitlement to vote. There are 4 prerequisites for entitlement to vote. 1, qualification to vote, registration, identification, and verification. More is intended by the right to vote than the bare right to place a ballot in the box. Our own Constitution sets 3 fundamental prerequisites for qualification, the first step for entitlement. That is to say, the individual must be 18 years of age or older, must be a citizen of Ghana, and must be of sound mind, Article 42. This qualifies you to vote. It does not entitle you to vote. So being a qualified voter is a necessary but not a sufficient condition for entitlement to vote. The manner of exercising the right to vote is as important as the right itself. Registration and identification prerequisites must also be satisfied. Beyond these indices of qualification to vote, the Constitution itself mandates the Electoral Commission under Article 51 to provide various substantive and procedural safeguards intended to prevent those not entitled to vote from voting and to prevent violations of the requirements. And flowing from that, the Electoral Commission developed a comprehensive scheme defining entitlement to vote. And one fundamental requirement, a safeguard designed to assure the integrity of the electoral process, was that the voter shall undergo biometric verification. The right of suffrage should be exercised within that limitation. So the statutory prescribed standards are intended to ensure that election officers verify the qualification, registration, identity of prospective voters before they are permitted to cast their votes. Ballots should be invalidated if election officers fail to follow the processes aimed at establishing a person's entitlement to vote. Such irregularity, with all due respect to the Supreme Court, totally undermines the basis of the determination of a person's right to vote, and hence opens up the probability that anyone can vote, notwithstanding constitutional and legislative injunctions. As one of my seniors said, show up and vote. It doesn't matter whether your name is in the register, it doesn't matter if you're being verified or not. The future is now, I shudder to say, show up and vote. A violation of any of the standards prescribed by the Constitution and the statute is an infringement on the Equal Protection Clause of the Constitution, and that infringement should necessarily lead to the nullification of the ballots in the affected polling stations. If the judiciary sanctions violations, it is an unequal evaluation of ballots. That is to say, some are being allowed to get away with blue murder and some are being scrutinized. Your vote is not more important than mine. Those who voted in Ghana without biometric verification, I'm telling you, I had to undergo strict verification because it was only on the 5th trial that I was allowed to vote. Your vote is not more important than mine. The net effect of the decision of the Supreme Court is this. It is a veiled but very strong suggestion that the court does not have power to nullify elections. That is what they are telling themselves.
Yeah.
The court does not have power to nullify elections. But I dare say that the power granted to the Supreme Court under Article 64 to declare the election of a president invalid envisages the annulment of votes. If you are declaring the election of someone as president invalid, it means you are annulling votes. If you are afraid of annulling votes, there can never be a situation where any election of a person can be declared invalid. To the extent that the Supreme Court decision espouses the outlined principles, I salute their lordships. But this is the problem. I can't find any semblance of these principles in the so-called majority decision. On another score, the so-called majority appeared to suggest that the pink sheets were so unreliable that it led the petitioners into error. I humbly ask a rhetorical question, and with that, I'll resume my seat. If the pink sheets were so unreliable, would they form the basis of the declaration of a person as president? I have no idea.
Good evening. I think, can I just take something from what Kisi, my classmate, said? Well, classmate, not intellectually, but at least he's he said, if I can rephrase it, and I think the professor also mentioned it, he said, the Constitution guarantees the right to vote, but not the right to cast a valid vote. Let's think about it seriously. The Constitution guarantees your right to vote, but not your right to a valid vote. That is determined by law. And I think it's an important distinction that the Supreme Court somehow ignored. I believe it was a professor who also mentioned that we've been haunted by Ria Koto. I believe this decision was worse than Ria Koto, and I'll tell you why. Ria Koto happened under a restrictive constitutional order. This constitution guarantees more judicial independence than the 1960 constitution. And yet, the judges somehow timidly restrain themselves. I have described the judgment as corrupt.
Yes, right. 100%.
That description is not based on the criminal interpretation of corruption in terms of money being taken. But when you give a decision which ignores the Constitution, but is more driven by a desire to protect the presidency rather than protecting and upholding the Constitution, that decision is a corruption of the Constitution.
Correct.
And I hope I don't have to apologize for that.
Yes.
Now let me get to the reforms. The judges proposed some reforms. Now it's important because whatever the case may be, we need to take something positive and constructive from this decision. Otherwise, we don't want a situation where people think that it means overvoting does not matter. It means BVD does not matter. It means constitutional provisions does not matter. We must make sure, whether we agree or disagree with the Constitution, how do we protect our electoral processes for the future? And that's where my focus is. Justice Atuguba did mention that the petition, however, has exposed the need for certain electoral reforms. I mentioned some of them, and everything I say here is a direct quote from the judgment. It says, the voters' register must be compiled and made available to the parties as early as possible. Let me critique that a bit. It means nothing. I think a better approach would be that CI 72 made no mention of when the completed register must be given to the political parties and the candidates. He only mentions the provisional register. And I believe if we are going to look at reforms based on this, we should set a date going back from the election day as to when the completed register, the full register, not the provisional one, is given to the political parties and the candidates, because you have independent candidates as well. Yes, but not a few days before the election, as we saw in Zimbabwe and in Ghana. And then he also mentioned a supplementary register may cater for late exigencies, such as what? When the court has stated clearly that after a certain date, your right to register is there, you can still register, but it would not automatically entitle you to vote. So I'm not too sure what Justice Atuguba meant by this. He also mentioned that the caliber of presiding officers must be greatly raised up. Certainly, he wasn't minded to raise them up in terms of their capacity in his judgment, but he wants the caliber to go up. And I think it's a good point that we can all learn from. He says the pink sheet is too elaborate. A much simpler one would be better, I suppose. I disagree with him. The pink sheet, there are 3 stages of filling the pink sheet. At the beginning of the election, before voting, you fill a part. After voting, there's a small part that you have to fill. And after you've counted the votes, there's just one part that you have to fill. I'm not too sure how elaborate this is. So what does he want us to do? We should forget the ballot accounting bit. Because if you've read the judgment, Justice Badegbe also mentioned that the ballot accounting part was so unreliable that it must be ignored. But if you can't account for the ballots, how do you account for the votes and for the declared results? It's such... Anyway, he also mentioned that, and I think we go to what Justice Jones-Doche said. But Justice Atuguba also mentioned that he said invalidating wholesale votes for insignificant excess numbers is not the best application of the administrative principle or the proportionality test. I also think this is also a gross misunderstanding of the electoral system. Because how do you get into the ballot box to determine who cast that invalid vote? So I'm not too sure what is his preferred application that will meet the proportionality test. Proportional to what? So maybe we need to also look at that, or at best ignore it. Now let's move to Justice Jones-Doche, who I think went a lot further in even critiquing decisions that the court itself took in the course of the trial. For instance, that they should have said no when the petitioners asked for the collation sheets and the pink sheets and all that. But he did mention, and he said, even though they cancelled, they basically dismissed the duplicate serial number bit, he mentioned that the pink sheets has informed me to suggest a number of reforms in our electoral process, including better management of the serial numbers on these pink sheets. And he goes on to say, it really does not make sense for the EC, Chairman Dr. Farijan, to state that it is the printers who generate the numbers on the pink sheets in order for them to keep count of the number of pink sheets they have printed. This is not only absurd, but also exposes the Electoral Commission as lacking any control mechanism to really check the actual number of pink sheets delivered to them. And he goes on to say that there's the need for the Inter-Party Advisory Committee to consider legislation to legitimize the use of serialized pink sheets in just the same way as they are unique polling station codes. He goes on to say, even though the above suggestion is likely to be a strain and an added burden on the Electoral Commission, it is better to put such a stringent requirement on them than to live the type of mess that was created by the lack of control in the printing, marking, distribution, and use of the pink sheets. Now, we've also spoken to a lot of people and analyzed, I'm talking about the Danquah Institute, the case and also the elections in 2012, and also come out with some proposals, and I'll just mention a few. We think that there could be a need for a constitutional review of the Electoral Commission, the appointment process, the tenure, the composition of its membership, and the accountability mechanisms of the EC. For instance, whereas a deputy regional minister goes to vetting, a Supreme Court judge goes to vetting, the chairman of the Electoral Commission does not go for vetting. Even a deputy regional minister goes for parliamentary vetting, but not the chairman of the Electoral Commission, who can be appointed at the age of 35 and stays on for the next 35 years. It's a serious matter. And I'm even surprised that when you look at the work of the Constitutional Review Commission, it is silent on this. And I think that is one area that we have to look. Also, there is an absence of accountability mechanism with the work of the EC. It appears that we are putting too much weight on its independence rather than its impartiality and its professionalism. And perhaps more importantly, on its integrity. And I think these things we can look at. Also, there can be some overhaul of the administration of the EC. I think the personnel. It is absolutely clear that the personnel, the quality of personnel at the EC is rather atrocious. At the IT department, the procurement processes, and all that can be looked at. We are also suggesting, for instance, that the returning officers must be made permanent staff by merging the position of district officer with returning officer. There are not almost as many district officers as there are returning officers. But why can't the district officers act as district officers and at the same time, when it comes to election, act as returning officers? So you have permanent staff being returning officers at the constituency level. And I think this is something that can be looked at. We saw that there were duplicate registrants on the so-called cleansed biometric voters register. We saw that. The court was silent about it. We think that there have been issues about the credibility of STL, even though that was not necessarily before court. We think it's important that there's an open tender for a new company to authenticate and clean up the biometric voter register of 2012. We don't have to go through the whole process of compiling a new register, but it has to be cleaned properly, and it can be done. For instance, Afarijan told the court that C3 was there because there was a number of people whose data went missing. He was never able to tell the court the exact number of people, yet a space was created for them. And I think we need to look at that. We also think that I think that's been mentioned, we should amend CR 72 to give a specific date before election day for the provision of the final register. We also think that we believe in Justice Doche that, and we'll go beyond that and say that we should strengthen IPAC. I don't think it is wrong and it may necessarily infringe the Constitution if we enact legislation to formalize IPAC in line with the constitutional independence of the EC. We can have formalized the role of IPAC without necessarily breaching the independence of the Electoral Commission as guaranteed by the Constitution. We also think that there should be a formation of regional inter-party advisory committee, and it should go all the way down to the constituency level, where in each district a rep from each party with a rep in parliament at least would constitute a team to monitor the activities of the district EC. We also think that the recruitment of temporary EC staff must be done not later than a month or so before election. And it should be done in a way that at least we are given enough notice. I remember in 2012, we saw an advert in the graphic, the next day it was over. It was as if the advert was done to meet a requirement, but not necessarily to, if you like, bring to life the purpose of that requirement. And we also think that for the temporary staff, registered members of political parties must be ineligible for recruitment. And when it comes to polling agents, we think we should look at state funding of political parties, but specifically in giving political parties and candidates some funding towards the recruitment, training, and even allowance for polling agents. Because the Supreme Court itself has put more weight on the presence of polling agents than on presiding officers. So the state must bear that burden.
Yes.
If you think that polling agents are what? Super agents, the state must make sure that they are there to do the work that they're supposed to do. We also think there's something that happened with CR 75 that we seem to forget. It actually reduced the powers of the polling agent and reduced the polling agent to a mere observer. In previous elections, political parties could send their best people to what they call difficult areas as polling agents. And then they were allowed to vote earlier as special voters. CR 75 specifically deliberately took that away. So you can only be a special voter if you are either a policeman or someone engaged by the Electoral Commission, not someone authorized by the Electoral Commission, which a polling agent could have been. So I think that CR 75 must be amended to allow polling agents to be special voters, because that will then give political parties the leverage to send people to different parts of the country. Because a lot of pinches that were brought to court, even though there were 2 agents there, you could see that in certain areas, candidates got 0. And your agents could not also vote anywhere else before coming. And these are the agents that we should trust their signatures. We also think there should be some modifications to the pink sheets. We think that section A of the pink sheet should include the question, what is the serial number of the BVD used for the polls at the station? It's important. Because if we know the serial number of the machine, they can't bring another machine to say that represents what happened, what was used at the polling station. We also think that section B should include what's the total number of people on the F4 list. We also think that it should also include how many people on the F4 list voted. So you can have a clear distinction between who comes under section regulation 32 rather than trying to push FOs under regulation 32, when the interpretation section is clear as to what biometric verification means. We also think that section C of the pink sheet would include the question, how many people voted with BVD in this polling station, but not on FO list. There are others that I think we can make all of these available on our website. We also think that a copy, that pink sheets must be signed by the presiding officer and agents and displayed to the public before the declaration of results at the polling station. We also think that a copy of the signature of every presiding officer must be available at a constituency collation center to be cross-checked by a returning officer and candidates agents with the signature on the pink sheet before tallying begins. So you can't then swap pink sheets and then find signatures and then we all have to accept them. It happened in court that the 17 pink sheets that they brought eventually, some of them had the signatures of polling agents. Where did they procure those signatures from? And the court was almost silent on that. I'm talking about the 17 pink sheets that came to the ones about finger of God that poked a Farijan. And we also think that pink sheets without signatures must not be added but placed in a special tamper-proof wallet and sent through the district EC officers to the National Center. We also think that Form EL23A, the collating sheet, should be modified to allow for candidates' reps to sign and provided a copy. A copy should also be displayed at Constitution Collation Center because the summary sheet tells you almost next to nothing. And the EL23A must have a column to indicate the serial number of the pink sheet alongside the polling station code. Like I said, I will want to end here, but let me just get to the transmission, transporting, declaration, and results gazette. We believe that the EC must emphasize the provisional nature of the results, indicating that the final results will be declared after all tallying have been completed and cross-checked at the National Tallying Center. And constituency returning officers shall be required to transport one EC copy each of all pink sheets, collation sheets, and results summary sheets of the presidential election at the National Tallying Center for central tallying and results finalization. What it means is that Dr. Farijan or whoever replaces him should not declare results without all the pink sheets, copies of them, coming to the National Tallying Center. If it takes 2 days, it's better than 8 months in court. Would you not agree? I think I will end here. Thank you very much for your attention.
Thank you very much. And instead of mentioning the names of the panelists one by one, I'd like to express our profound gratitude, especially for those of us who listened to you here. The light that you've thrown on this entire judgment for all of us. We are most grateful. Shall I please give them a round of applause? Time is fast spent, so I would like to call Nana Santibidi to give us the closing remarks and vote of thanks.
Thank you very much. I think we've all enjoyed this presentation. As always, my president, Mr. Sam Akufo-Addo, has brought gravitas to these proceedings, and we thank him a great deal. Professor Frimpong, who I had heard a great deal about it, but haven't had the pleasure of meeting. Thank you very much. Steve Pfeiffer at Fulbright says I should say hello to you. Mr. Moderator, entertaining and engaging as always. Thank you very much. And Mr. Kisses Jabing, somebody who he's my hero. I admire him such a great deal, and I think he did a brilliant job in his presentation. Thank you very much, Kisi. I think we also, as is customary and important, have to thank God for bringing us all here. Some of us may not have survived the verdict, so we're lucky to be alive. And the Danquah Institute for bringing these proceedings to us and to the public out there. I think a lot of people have been educated today. And of course, the audience for coming and showing your support. It shows that constitutionalism is alive and well in this country. People are very interested, and it is important that we continuously engage the public with these matters so they do not become some obscure matters that are dealt with at in the academies. So we thank you very, very much for coming. I think most of the questions that I had posed in my opening remarks have been answered by the panelists, and it gives us all food for thought to consider as we leave here, and most importantly, the reforms that have been suggested, we hope will be brought to bear on our future electoral processes and improve our electoral system. I thank you from Danquah Institute, and wish you well. God grant us all traveling mercies, and I hope you see you next time at the next Danquah Institute program. Thank you very much.
Please, we'll take a very quick closing prayer from the Reverend Asante Nchi.
Shall we pray? And before that, let me make a very poignant statement. Truth, temporarily defeated, is stronger than evil triumphant. Let us pray. Let us go into the world in peace. Let us be of good courage. Hold fast that which is true. Render to no person evil for evil. Let us support the weak, help the afflicted, honor all people, love and serve the Lord. Amen.
Amen.